Good afternoon. Not legal advice. Like, subscribe, share, comment. Wasn't planning necessarily to do a video today, but I elected to because of certain events. I decided to kind of combine a couple things and go from there. But before I start with that, I wanted to send out some really helpful advice, at least advice that I, in particular, and my dogs find really helpful, and that is, if you are attacked by a mob of clowns, go for the jugular. Anyway, so tonight I'm going to talk about a couple things, and again, not legal advice. Like, subscribe, etc. I appreciate you watching. I was going to talk about, I'm in an arbitration with Fidelity, and I said I'd be transparent and keep everybody apprised as we go. And I wanted to talk about that. And then I was going to talk about AST a little bit, since I've elected to take certain action as to AST. So in this concise a fashion, I'm going to deal with both, or try to. So first, as to the Fidelity arbitration, you know, it's a Finra controlled arbitration. I may be filing other things and asserting other issues with regard to the arbitration, but at this point in time, so I filed a complaint with Finra. Finra then served that complaint onto Fidelity. Fidelity, I think, had 60 days to answer, even though we're in an expedited proceeding, and they just answered within the last 2 days. So I've briefly reviewed the answer. It's lengthy. It's probably around 20 pages, 22 pages, has a bunch of exhibits attached, some of which I'm just going to briefly talk about because I found it interesting. But it basically says, to summarize, I would say, it basically says this is a self-directed account. The fact that you got screwed, and I'm paraphrasing, by the way, the fact that you got screwed, that's on you, and you were going for a short squeeze, and you were wrong. So that's part of it. There's also legal argument as to individual claims. I think I filed like 19 different claims. So there's a whole bunch of claims. They attack that, and they basically say that they had no duty. So that they take the position that they are not responsible for the fact that the security that they sold you was defective or was counterfeit or didn't exist. That's their basic position. They also try to belittle the claims. They often call it baseless. At one point in time, they claim claimants' claims are ridiculous. A legal mountain of utterly frivolous disputes. I'm just reading from the filing. And they also reference, so on one occasion they reference, I'm a experienced real estate and business litigator, which is true. But they also indicate that I've done securities litigation, and that I filed to block a merger. So I had one case I did like that, which was on my own stock, by the way. I initiated an action after the IPO and merger involving Lucid because I claimed before the merger that they were misrepresenting their future production. What happened is I ended up I tried to get the merger blocked, just going for the gusto, and that was denied, but the action was not dismissed. There was another class action that was ongoing, and I was given the opportunity to wait to see how that goes before the case is on. But anyway, they cite that. They also cite many times that it's baseless. I'm just kind of, whatever, I'm trying to use the specific language, which is interesting. The most important part I thought was, and this told me a lot, this answer was filed, I believe, July 31st, and the letter from the Congress people went out on July 28th. So there were two headings in particular that struck me. It struck me with regard to the intentions of the attorneys representing Fidelity. So the first one was, there's no basis for the claim of illegal short selling or market manipulation. Now, I think, notwithstanding other things, the fact that there's a bunch of congressmen, Congress people, and now a senator on the other side now also concerned about what went on might be evidence or suggestive of manipulative practices. And it's ironic that even though that event occurred before they filed their answer, they neglected to reference that. Interesting. I find it interesting and disturbing, to be quite honest, and deceptive. Additionally, they also claim there's no evidence, or the claim, Ray, because I asserted there was an investigation that apparently was going on prior to the U3 halt, and I used that based upon the FOIA reply. And one of their headings is there's no basis for, actually they say it's baseless. The allegations of an investigation were baseless. However, I had previously sent him that FOIA reply and the documents, so I found it interesting and perhaps slightly deceptive and false that they were pretending like there was no evidence of investigation. So those were just two things. They basically denied responsibility. That's their position. What I found, besides the things that I'm stating here in general, and I'm going to do discovery as to that. So I indicated before that I'm preparing a discovery motion, which is in process, and I'm going to seek the depositions of various parties, all of which we've talked about: Finra personnel, people at Fidelity, the person at Finra who just wrote those most recent letters, and then somebody who they disclosed in their answer. So, as I said, they had some attachments. They attached, I think, my account information, perhaps, because that's confidential, theoretically, within this. That's why I'm not showing you the document, I'm just talking about it. The other thing was they attached as an exhibit the FAQ from March, which I find interesting because I'm probably going to use it against them in a rebuttal to their answer, and I'll get to that in a second. But the other thing they attached was the article, the Looney Tunes article from Brandon Kokadin, I think that's his name, or Kokadin. I'm sorry to butcher his name, but that article about the loony short sellers, the US, that was put out by them, and Forbes, I think, is the publication, but was put out about a month after SEC indicted someone for naked short selling, after that bankruptcy court in Sorrento Therapeutics found there was naked short selling, before Congress came out with those 15 or 16 or 17 Congress people who are after Gensler, plus the new senator. So it kind of makes that particular individual they're relying upon somewhat preposterous, but it also adds him to my potential witness list. Since they've brought him up, I'm going to add him. And, if anybody has any background information about Brandon Kokadin, or his correct name, at least, and make sure it's in very concise form, please send it to little JR for me. That would be appreciated. And just understand, if you send me something that eventually I use, that might put you in the stream of discovery. And if you don't want to be involved, then don't send me anything. And if you do, there's a possibility you might have to testify. So it's kind of keeping that in mind. But if you have anything that's specifically you think would bring down somebody like Brandon Kogaden, get it to little JR, tiny JR, you know who he is. He's quite a member of this community, quite a fine guy, my little buddy. But get it to him and anything along those lines. So those are the two things that were attached, the FAQ and that article. And so as a result, besides doing the discovery motion and adding to the personnel, and basically here we go. So the discovery motion, and nothing to be hidden about here, discovery motion in an arbitration. So I've gotten the answer, and now we're in a discovery phase. There should be some exchange of documents, but for depositions, you have to get approval of the arbitration panel. We just got a list of potential arbitrators, but I haven't reviewed them or made any selections. But in the interim, I'm filing the motion for discovery because so generally depositions are not permitted unless there's extraordinary circumstances. In this case, the U3 halt in and of itself would be extraordinary circumstances, but now we have Congress and a senator going after the head of the SEC over the security. So I think that amounts to extraordinary circumstances, but we will see how this panel evaluates that. And I'll have to kind of decide what I'm going to do with the panel, with the Finra aligned board as we go. So, but just to bring you up to speed, so Fidelity is now answered. I'm going to file a response, and I normally would not file a response, but because I found some of their accusations trying to sway the opinion unfairly of future arbiters, I'm going to put things in context to point out the true facts, and then we can argue about who's right or wrong. And on top of that, I'm submitting a discovery motion that'll be there also, that I think will be very justified in terms of who will be chosen to come forward. And as we go, I'll keep you apprised as we go. But that's where we are as of today, to up to speed. So second, and separate and apart from that, with regard to MMTLP, I know we had Will Stewart on, and there was an issue about transferring shares to AST, and I know nobody really knows what I've heard rumors about what the share counts are and what the authorized shares are and issued shares are, and again, not legal advice. And by the way, despite the high cost of living, it still remains very popular. But anyway, as to AST, I just thought there was a lot of uncertainty. So it occurred to me after I spoke to a couple people, and I didn't want to interfere or step on any toes, and I don't know how it's going to turn out, but I figure why not give it a shot? Because if we can find out, because I don't understand why, but nobody's been able to get the AST numbers to this point, and perhaps there are certain entities that might be able to have standing to make that request. I don't know. But as to myself being a shareholder, I thought, why not? Give it a shot. Again, I'm in a unique position to be able to do it, so I, notwithstanding the amount of time it requires or the outcome, I'm going to go forward. And again, if I was doing this for a client, I would handle it differently, because my client currently is very understanding. So he's willing to take, gambles, and not that the facts don't support him, but gambles in that you don't know how it's going to turn out. So, submitted to AST, said I was going to make a demand, and I did today. I emailed it in Federal Express to them in New York. I made the demand for them to, and I gave a basic explanation, and again, I'm not going to disclose the document itself at this point, but I made an explanation as to why, because of I call it the dividend-like amount, because of the confusion, the investigations, everything, that a share count was important, and that I gave them 7 days to provide me that share count, and I went into a little more detail than what I just did. But basically, I set forth reasons why we needed the share count. I asked for it, and I said, if you don't give it to us, then I'm going to have to sue you and go into court and try to get it. I think I have standing, and I certainly have arguments as to standing as a shareholder, and I may do other things to cement that, but I think I'm in position as to that, certainly to make a good faith argument as to that, and as to the necessity to know for myself and for really the whole community. But we will see. So I gave them a week. Do I think they'll respond? I don't know. Generally I expect no. That's in all my letters I send out. I expect most other lawyers to say no and make you work for it. So, but I have to give them an appropriate amount of time so that if I go into court, I can say I gave them the appropriate amount of time and they elected not to. I'm only asking for a share count, not confidential information beyond that. So it should be easy to comply with the request about both the MMTLP and or NextBridge or whatever the designation they're using share count currently at AST as of the day they tell me that amount. Should be easy to say. I requested no confidential information. I said it'd be easy, and again I said if you don't get it to me in a week, then I'll file a lawsuit. So whether I like to or not, if they don't get it to me in a week, I will file a lawsuit, and then I will go into court on some type of ex parte basis and try to get a court order directing them to release that information. I do not know if it's going to be successful, but I think we have a good faith argument for going forward with that. I really do, obviously, especially in light of the most recent events, and it's worth trying, and hopefully the judge will be sympathetic to our position. So those are the two things that are going on, the answer and what I'm doing post the answer against Fidelity. And I want to just let you guys know, just so that if you're ever in the position of a arbitration, you'll have a little background of what goes on, and also just so you could follow this and maybe something productive will come out of it that might help you if you proceed the same way. As to AST, obviously, we've got to see what's going to happen. Hopefully we can generate a share count. Seems like to me that that share count really is an essential piece of data. And ironically, I noticed that after, and I'll take 100% credit and responsibility for this, but after I indicated last night, it was after Will Stewart, not Will Smith, after Will Stewart, and then after came on our live stream with little tiny JR, and then I indicated I was going to make a demand, and then I noticed there was a FAQ today from NextBridge in the afternoon, and it referenced the share count at NextBridge. So I appreciate they put it in there. It'll help me in my motion if AST doesn't comply. Anyway, hope that provides detail. I'm trying to be like an open book. And again, bottom line is any position that I'm taking in good faith. How it turns out, I don't know because I don't have control over the judges. But we're going to keep on pushing away and pressing forward until this is over. That is the promise. So hang in there. Keep pushing forward. Wish me luck. Say hello to your dogs. Pet them nicely. Take care.